Good evening, everyone, and welcome to Special Education Legal Fund's very first webinar of 2024. My name is Christine Lai, and I'm the Executive Director and Co-Founder of Special Education Legal Fund. Thank you to tonight's featured sponsors, the Pinnacle School and the Spire School. The Pinnacle School, which is located in Stamford, Connecticut, is redefining education for students with complex learning challenges through integrated support for language-based learning differences, ADHD, or mild autism. The Spire School, also located in Stamford, is a private therapeutic day school integrating an individualized education with health and wellness for college-bound students in grades 8 through 12. Thank you, Pinnacle, Spire, and the Greenwich Education Group for your support of S.E.L.F. and this webinar series. Not to get away from myself, next I want to thank the rest of our corporate sponsors. Their generous support makes this webinar program, as well as so much else of what we do, possible. Thank you to Wealth Spire Advisors, our platinum level sponsor, our gold level sponsor, Winston Preparatory School, our silver level sponsors, American School for the Deaf, Fusion Academy, Villa Maria School, Eagle Hill School, and Chapel Haven Schliefer School. And at the bronze level, the Shrub Oak International School, in addition to Pinnacle and Spire. Thank you very much to our sponsors. For those of you who aren't familiar with S.E.L.F., I'm going to take a moment to introduce ourselves. Special Education Legal Fund was founded in 2018 to provide resources, knowledge, and support to families in need with children in the special education system. Since that time, we've provided over $800,000 in grants for legal support to over 200 families across 70 school districts in Connecticut and Westchester County. We do this primarily through two grants programs that we provide for families, the Legal Assistance Program and the Advocacy Support Program, both of which are currently accepting applications. The Legal Assistance Program, the Attorney Program, provides up to $6,000 in support, and the Advocacy Support Program up to $1,000 in advocacy support. To begin the process, please visit our website, www.spedlegalfund.org, and begin the pre-screening process. I'm going to talk kind of briefly about the grants process, because I've gotten a lot of questions about this. The process is 4 steps: the pre-screen, the application, the interview, and the notification. When you do the pre-screening on our website, it is a 4-question survey, and that is not the application. I get a lot of calls from people who have finished that and then are asking me where their grant is, and that is like just 1/4 of the process. After you finish the pre-screen, you will get an application via email. You will fill that out through the link, attach your IEP, and then once we receive that and your documents, we will contact you for an interview. You absolutely have to complete the interview in order to be considered for a grant. And we do those, all the time. They last between 45 minutes and an hour. And, they're very, very easy and simple to schedule. You have until the 15th of each month to complete the application with the documents, and until the 22nd to complete the interview. After that, we will notify every person that applies for a grant during the month in which they apply by the end of that month. So for January, we are well into the January, review period. The applications were due by the 15th. Interviews are going on now, and we will notify families that applied by the end of the month, as by the 31st. Next month, after next month's webinar, or before next month's webinar, I should say, I'm going to talk a little bit about what happens after the approval process. But just for now, that's a brief overview of how the application process works for both grants programs. Next week is our 4th in the Lunch and Learn webinar series with special education advocate Virginia Blum. This month's presentation is going to be on present levels of performance and goals. And we will wrap up this series with preparing for the annual review meeting on February 27th. So just 2 more Lunch and Learns with Virginia left this year. And our next webinar coming up on autism will be on February 28th, 7 o'clock, and we'll be featuring special education advocate Julie Swanson, attorney Melissa Gagne, Charlie Manos from the Pinnacle School, and Gina Apicella from Chapel Haven. So we are going to tackle the topic of supporting students with autism in schools, and all of our participants in this panel are very, very well qualified to, to talk with us about that. And that brings us finally to our panelists for the evening. We are absolutely thrilled to welcome Andy Feinstein back to the Five Timers Club, actually, here in the at the S.E.L.F. webinar series. Unfortunately, you don't get a fun jacket or anything like that. It's not like the Masters, but Andy has previously appeared on webinars, including outplacement, which you've done multiple times, state complaints, the year in review, and now tonight's webinar on mediation and due process. There really isn't much that Andy doesn't know about special education law. He's actually forgotten more than most people know. And we are, really, really grateful for his support over the years, going back to when we were just an idea, really. Andy was the recent recipient of our inaugural President George H.W. Bush Disability Advocacy Award, which was presented at our 5th anniversary gala back in November. Through his practice and his work through COPA and S.E.L.F, he is a tireless advocate for children and families in the special education system in Connecticut and beyond. So welcome back, Andy. Our next panelist is Jeff Forte, and we are really thrilled to welcome Jeff back to the webinar series. This is your 4th appearance on a S.E.L.F. webinar panel. You've previously appeared, he's previously shared his expertise on, the summer slide, which was on ESY, outplacement, and also the new Connecticut IEP, which was a barn burner. That was a really good one. Jeff is a great friend of S.E.L.F. and a phenomenal resource for our families, as well as families across the state of Connecticut who are struggling with the special education process. And he has particular insight with students that are within the juvenile justice system. So welcome back to our panel, Jeff. And finally, last but certainly not least, we are welcoming Jennifer Laviano back to our webinar series. Jen has previously appeared on our extremely popular panel, Attorneys and Advocates, What's the Difference? And she is a force in special education law in Connecticut, both through her practice, her work on behalf of families with S.E.L.F and COPA, her book, Special Education Rights, What Your School District Isn't Telling You, which was co-authored with advocate Julie Swanson. And she's, second generation special education, law in our state, following in her father's, big footsteps. So we're really excited to welcome Jen back to our webinar series. Finally, since it would not be a webinar without a disclaimer, this webinar panel is presented for informational purposes only. This webinar is intended as a resource for families who are navigating the special education system in Connecticut and New York, and is not intended to provide legal support, advice, or assistance to any particular individual, nor is it intended to replace the advice and counsel of a qualified special education attorney. Families in need of legal advice, support, or assistance should contact a special education attorney licensed to practice in Connecticut, New York, or the state that they live to discuss the specific needs of their individual student. This webinar should not be construed as an endorsement by Special Education Legal Fund or any of its representatives of any of the participating attorneys, advocates, or other professionals in the panel, nor is it an endorsement of any school or school representative invited to appear in this series. And with that, welcome to Mediation and Due Process. So, this is obviously a topic that, we could spend forever on, several different webinars. I'm going to back this up a little bit. Conflicts obviously arise in every part of our lives. And when conflicts arise in our kind of, quote, regular lives, very often those conflicts can be resolved in the judicial process. Similarly, during this course of someone's special education journey, parents can find themselves in conflict with their school team and their school district over identification, evaluations, placement, services, goals. And those conflicts arise, but they're handled in a different way. They're handled in a different way than they would be in our regular lives. They don't go through, a judicial process in the way that, they don't go through our regular court system or whatever. They have their own process. And tonight I'm really pleased to welcome this attorney panel, this incredibly, distinguished attorney panel, to talk about conflict resolution in the special education process, and more specifically, due process hearings and mediation. So, we kind of started out, and I want to throw this sort of out there for you guys. Very often, a family is faced with a choice where a school district has presented a plan, an educational plan for a child, and the parent doesn't agree. When the two sides are in conflict in that instance, can you describe the process moving forward? How do families and schools resolve that conflict when there's a disagreement about the placement of a child?
So, I'll start. The hope is that you can resolve it at the IEP table, right? That's the hope. But when you don't, when you can't end an IEP meeting with a consensus about what the child requires, parents have available a few options, and the two that we're focused on are mediation and due process. Mediation is a structured settlement conference with an independent contractor who's paid for and hired by the State Department of Education and trained in the IDEA, the Individuals with Disabilities Education Act, which is the federal statute that governs special education. And that person's also presumably has training in mediation and in assisting people to come to a consensus and a settlement. It's a very different process than due process. Due process is essentially beginning the first stages of litigation against your school district and going through an administrative agency process in order to have a mini trial. It's an easy way to look at it. In Connecticut anyway, that's the way it functions, is a lengthy due process hearing, usually about 10 to 11 days of testimony, witnesses, exhibits, things of that nature. What I would say is you can file for a due process hearing and still pursue mediation. You can pursue mediation at any stage of the process. You don't have to have a hearing pending in order to ask for mediation. But I think it kind of depends on what's happening in the case, how urgent the situation is for the child. That will factor in significantly as to whether you pursue mediation or due process. And there are some circumstances where a parent really should be pursuing due process rather than mediation if, as an example, the child's placement is being proposed to be changed and the parent disagrees, discipline issues, expulsion hearings, things of that nature. So it really does depend, just like everything else, on the individual needs of the child and where the family is in the process and the relationship with the school district.
Jeff?
Even earlier than that.
Andy?
So I get a call from somebody in disagreement. I will often give them some advice as to how to approach the school district themselves to try to resolve it. First. Second, I will then call the lawyer for the district usually and see if we can work something out before going to mediation. Surprisingly, well, maybe not surprisingly, in many cases, the lawyer for the district tells me that the district needs mediation in order to resolve it. And that's because of the internal politics, I suppose, of the district. It's not my problem to understand their internal politics, but if they need mediation to solve it, I'm going to be agreeable to mediation. I prefer to. I look at everything in a bottom line approach. So if the parents are the total value of the settlement is obviously reduced by my costs, and if I can keep my costs down, the value of the settlement goes up. And even if we settle for somewhat less, if my costs are that much lower, it's probably a win for the parents. And I think that's really important to keep in mind, because at least in my mind, I would far prefer parents spend money on the education of their children than on me.
Jeff?
Yeah, sure. I mean, at the end of the day, we're talking about a child's education. So it's important to try to resolve it quickly for the betterment of advancing the child's programming, right? So, we often will sometimes get calls from parents, understandably, are incredibly emotional, and they're letting their emotions get the better of them, where, they may want to be filing for due process for for emotional reasons, for revenge or vengeance type of thing, to get back at a team that's failing their child. And that team may very well be failing their child, but you need to couch the issues in a way to prove your evidence at hearing that the child's not making educational progress, or that the IEP is not being implemented with fidelity, or the child's not been given an IEP, right? So you have to know what your big ask is, usually when you're speaking with an attorney or an advocate. And to kind of go back to the IEP PPT table, right? You're going to want to know what your asks are and your deliverables are. And if they're refused, put them on prior written notice. So you're starting to set the stage, if you will, for a dispute that needs to be resolved. And usually things can get resolved that way, either at the IEP meeting or post IEP meeting, right? Even before you're getting to mediation or due process. But you're going to want to know what the legal issues are that you're contesting, so that you can present them in a way that creates a substantive violation under the Individuals with Disabilities Education Act, or procedural violation.
Let me move back a little bit from that. The fundamental question in these hearings is whether the district has offered your child a free, appropriate public education, and that's been defined a very low standard, as suitably ambitious, but a individualized program that allows your child to make meaningful educational progress. And your job, our job, is to prove that the district did not do so. So that leads to rule number 1, 2, 3, and 4. You cannot win a hearing without an expert. You can't win a hearing without an expert. You can't do it. And so you really need somebody, a psychologist, a psychiatrist, an educational consultant, who's going to say that the program offered by the district fails to offer this child a free, appropriate public education. Now, you don't need that probably until hearing, but in mediation, the district is going to give you less if they don't think you have a serious case, and more if they feel vulnerable. And so if you have your expert before mediation, and then you have a report that's given to them in advance that says you have this person with lots of letters after their name saying the district failed to provide an appropriate program, failed to offer an appropriate program, they're going to settle for a lot more because they feel vulnerable, even if they feel, in their hearts that they offered an appropriate program. But that's the issue. And the issue of appropriateness is inherently something that needs expert opinion. And that's just the way the system works. And I'm sorry about that, but because experts cost money.
I mean, that's an important point that you make in terms of, what this process looks like. You also make a point, kind of, softly, that, these two things are not necessarily, it's not really binary, it's not, mediation or due process, really. It's, they're both kind of part and parcel of the whole process. Can you talk a little bit about, any of you, about what mediation looks like versus what due process looks like?
Sure. So they're very, very, very different.
No, absolutely.
Mediation is confidential. It is usually a one-day event. Sometimes we go back to mediation more than once for various reasons, but it usually goes around 10 to 4. Okay. So both sides are in separate rooms. We do them virtually now, but the process is essentially the same. You're in one virtual room, the school district and their attorney are in another virtual room, and the mediator goes back and forth between those rooms. Because it's confidential, there's really the only record that's kept of it is the notice of the meeting, and if you do reach an agreement, the contract. Anything else is really internal notes. It's not really something that is out there. And for that reason, it's a lot less pressure in some ways on families, because in an IEP meeting and certainly in a hearing when you're on the record and testifying, you know, what you say can very much alter the course of the case, which can happen in mediation too, if things go south or sideways for whatever reason. But if my client says something in a mediation to the mediator that isn't very helpful, I'll just ask the mediator not to share that with the other side. I tell my clients when we prepare for mediation, other than I don't really live in this school district, there's not a lot that you could say in a mediation that's going to be fatal to your case.
Right.
Because the mediators, we have ground rules, and they respect that if there's something that the family doesn't want to share, unless it's very compelling reason to share it, they won't. Due process is like a trial. You've got
Right.
people on the record, you've sworn in. It is very adversarial. There are objections there, and for families who, especially if their child is still in the district and it's not a hearing about an out of district placement reimbursement. If your child's still going to that school every day and you're sitting in a room while your lawyer is cross-examining your child's teachers, it's a very uncomfortable situation to go through, which is why every one of us would tell you that due process is a last resort after you've tried everything you can possibly do to resolve your case.
And, you know, since during and after COVID, mediation has now, I think, been more streamlined in that it's all essentially remote. I mean, we were just talking before we got on, Andy, Jen, and I, and to our knowledge, you know, we all haven't done an in-person mediation, you know, separately with our clients since COVID. So mediation is really where you're in a space like this, and you have the mediator that bounces back between your parent chat room and the school district chat room, and the mediator will introduce themselves, kind of establish some of what the mediator's ground rules are for the day. As Jen mentioned, it's usually a day that they're actually shorter now. They usually start more around like 10 o'clock and end around 4. That's if you get that far, if you get that long. And, you know, you go several rounds of negotiations about the issues that you're wanting to resolve. You know, I would say that the most important thing for parents to know about mediation, especially if they're doing it pro se, is that in the other room, there's going to be the special education director and, you know, maybe, you know, someone on the team, right? But
Can you explain pro se? Just
pro se, meaning they're not represented by
An
a
attorney.
lawyer, or they're not bringing an advocate with them. They're doing it individually on their own. So let's say they're doing it on their own. This is probably going to be, generally speaking, their very first experience at mediation. Whereas the school district does this every day. You know, every day might be an exaggeration, but they do it a lot.
Right.
And the SPED director, the special education director of your school district, has the board lawyer on, you know, speed dial.
Mhm.
In case there's an issue, they can get legal counsel on. So parents that are going into this individually need to know what they know and what they don't know, and they know less about mediation. So you really have to, you know, learn about it and understand what the needs are that your child, you feel that they need, and then how to successfully negotiate that to the mediator to be an extension of your requests to the special education director.
Let me take you through the day. So you start, Jeff said they're shorter, and I don't agree. I don't agree with him particularly on that, except they are shorter because when the mediator's not with you, you can go do other things. Whereas in the old days, you know, we'd sit chatting with
You were
clients.
sitting in a room in the Board of Education with your lawyer all day. Having done it myself, it's a long day.
So you start off, and the mediator usually meets with the parent first, and the parent gets to tell their story. It is, as a matter of law, you can only get relief for the last 2 years. So in telling your story, you can tell early history, but certainly don't dwell on it because it's not really relevant. And the story has got to be about the kid's educational need. Way too often parents take it all all too personally and think it's all about them and what they did. That's not really important. And, the message is to watch the eyes of the mediator and make sure that are there any he mediators now? I don't think so. That she is interested and focused. If she starts drifting off, shorten your story. If she's interested at a point, pursue it. Then you end up with your demand, what you want, whether it's money or placement or whatever. And you've got to lay out in great specificity exactly what you're looking for. The mediator, that could take a half hour, 45 minutes, maybe more. I think taking more is probably a mistake. Mediator then goes away, usually for at least an hour. Don't try to read anything into that. Often the mediator goes and presents what you said to the other side. Then the mediator waits out in the hall or wherever, or in her own living room now, until the board is ready to come back with their answer, their proposal, whatever. They then come back to you, and this is now like noon usually, and with the board's offer. My instructions to clients are to adopt a poker face, make sure you understand exactly what's being offered, then go offline and discuss it, and discuss what you want to do as a counter proposal. Ordinarily, we'll go 4 or 5 rounds before we get close. But if you're not within range at like 2:30, you're probably not going to settle it. But it's and a good mediator will try to find other ways to skin the cat, other approaches that can meet the needs of both sides. Often that's not possible, but often it is quite possible. When there's agreement, the mediator should be coming in with a script and tell you exactly what they've agreed to, and reading exactly the same script to the district. Then ordinarily the district lawyer will draft up the agreement. They will promise it in the next few days, and you'll get it sometime in the next month. Then you want to review that quite closely. If you are not using a lawyer in mediation, you probably want to take it to a lawyer for an hour to review it, to see whether there are any games being played in it. And then you sign it, and it's a binding contract, enforceable as a contract in state court. It is not, enforceable by the Department of Education. Unlike our colleagues in other states, we are rather lucky in Connecticut. I've not had a whole lot of mediation agreements which have been ignored or violated by
right.
districts.
I've
In
only
other
heard of
states-
one in my, last 6 years.
Well, if it's negotiated in mediation under the IDA, it's enforceable in federal court. So that's usually all you have to threaten, and that's the end of the conversation. Do I have to go to a federal judge to get you to comply with this settlement agreement? And usually that does it. I just want to say one other thing that weighs in favor of mediation, which is you can ask for things in mediation that I would never advise a parent to ask for in an IEP meeting, and certainly wouldn't advise them to go forward in a hearing over, such as certain personnel working with your child, certain classrooms, things that might impact siblings. Even, if the district says, okay, we have a different program in our district at a different elementary school, and we're happy to have your child go to that program. Then in mediation, you can say, all right, well, the parents want the children in the same school. Can you have their little brother or sister or whatever, go with them? So there are things that you can negotiate in mediation that I would never advise a parent to put on the IEP table or go forward in a hearing over.
This goes to a question that I got from the audience, which is, when you go into mediation, maybe you can address this, Jeff, along with everyone else. Should you have a clear ask of what you want and have a range of what is acceptable, or should you go in with more of an open mind and hear what the district is willing to offer, or both? What's a good strategy?
Yeah, well, so obviously, if you're going to be going with an advocate or an attorney, you're really preparing for this. You're having a pre-mediation meeting with your client. You are going to develop very clear asks and your lawyer or your advocate is most likely going to be giving you a range of probability of the likelihood of your asks being granted on some level, downright denied, or not to bring it up. But if you're going pro se, I think the answer is still the same. Like you want to come in incredibly prepared. You just don't want to go in and wing it and see what the district's going to offer you, because they might not know what you want, right? So it's important to be pretty prepared for this. If you're talking, a range where you're seeking an outplacement, for example, or you unilaterally place, or you're intending to unilaterally place but haven't fully unilaterally placed yet, you're going to want to know the cost of the program. You're going to want to know the mileage to the school
program,
or
yeah.
transportation. You're going to, as Jen was mentioning, you can negotiate things beyond in mediation. You're going to want to know if you can have any wiggle room as to who the next round of triennial evaluators that you want to select would be, and if there's some agreement on that, because mediation usually has like a finite amount of time. And once that time is up, you have to go back and negotiate it all over again, either at another mediation or through the IEP process or another due process complaint. So you want to be as prepared as possible.
One thing I want to say is that, the sort of conventional literature on mediation says you should have a firm bottom line before you enter. I don't agree with that. I think that there's a lot to be discussed between, you and your partner, and between you and your lawyer during the course of it. And frankly, we all learn a lot during the course of mediation about the strengths and weaknesses of a case.
Mhm.
And, if it could start off with us thinking it's a 70% case, and after mediation, you think it's a 55% case. And, you ought to be listening to that and open to a settlement if it's, if you want to gamble, go to Foxwoods. If you want to provide education for your kids, come up with a reasonable settlement of mediation.
Do you advocate, obviously mediation is about coming to a middle ground, and between, the school district, which is at 0, and you who are at, 100, obviously, ideally you would end up, kind of at 50. So everybody's unhappy in the process. Do you have a like a strategy, where you encourage parents to, so in an outplacement agreement, obviously the tuition is what you are, is what you're talking about, the tuition and transportation, basically. But there's other things that, that might have come into the process. There could be a neuropsych that you paid for. There could be the, therapies that you are paying for independently while you were waiting for this, or trying to work through this process. How many of those other things should be thrown into the mix, or should they not?
So I would say that anything within the last 2 years, which is our statute of limitations, that the family has funded towards their child's education, we've put on the table. And things that, it depends on the family. Some families are in a better financial position to absorb some of their past costs than others. Some families have great insurance that covers some of the therapies, and others don't. So it always depends on that. But I also, when I'm in a position to do so, will point out things that I will request if I'm forced to go forward in filing a due process hearing, but that the parents are willing to absorb now, and we let the mediator know that. Say, just so you're aware, the parents have been paying an extensive amount of money for private tutoring during this entire time. We're not asking for that today.
Right.
If they force
but we
us
will if
we
we
will.
have to go to hearing.
Exactly. Right. So I think it depends on the family and what's urgent for them. But I do agree with Andy that while I tell parents in my preparation, give some thought to where you want to walk out of that meeting with, what your close to bottom line is, or what you're willing. Always something comes up in the mediation that is that gives me information that I would say to the parent, hearing that, I think maybe you shouldn't fight over that occupational therapy service, because I didn't realize that they had actually offered
you
that,
something, yeah,
wasn't in
right.
the records or whatever. So you have to be creative. You have to be willing to be creative. I mean, we end mediations frequently with, we clearly are at an impasse. Let's bring in a mutually selected evaluator to tell us whether or not you're right or we're right. That's a good way to end a mediation if you
Or like
think
an educational consultant, to maybe construct a plan or something.
or so, what some third party, because while the mediator is very important, that they're not a decision maker. They're not going to listen to what you have to say, what they have to say, and say, the parent is clearly right on this point. That's what a hearing officer does. You go to a hearing or a judge. So you do have to be creative and open-minded. Sometimes parents come in looking for one program and the school surprises us and says, we just really don't think that's the right fit, but we are willing to look at this other program. And if the family hasn't seen it yet and I think it's decent, I'll have them go.
Let me talk about two big issues. One, under federal law, advocate fees are never recoverable. You're not going to get your advocate fees. It's probably bad law. Attorney's fees, I generally ask for the mediation. They are always the first thing that the district says no, except in the case of impoverished clients. In the case of impoverished clients, I'll fight for them, and we'll sometimes get them. But if you're if you're paying privately, it's very unlikely that the district's ever going to agree to pay it.
To pay attorney's fees. Yeah.
And so moreover, this is more of a lawyer issue, but if the district offers pretty much what you want and doesn't agree to fees, we can't go forward on a hearing just to get fees.
Just to get fees, right.
That does not work well. So it's and that being the case, well, two things. One, there are many mediations where if I extend it for another couple of hours, I might be able to get another few bucks for you. But it's probably going to be a wash. Moreover, in virtually every case, the parents have to continue to work with the district, and going for that last ounce from the district is often ends up with a really counterproductive result, a real hostility, which is going to hurt the parents in the future.
Yeah, there was a recent case that I did with S.E.L.F. And getting back to a question, should you go in with like a reasonable amount or a high, low, and so forth? And it really depends on the strength of the case, right? And you can often tell what a district's thinking by their initial offer, right? Like if they're just gonna just completely lowball you, you're in for a very long day, right? But if they're coming in and, Andy's saying, we'll all bluff, we'll put on our poker face, right? But if the number's like, that's a pretty respectable initial offer, right? That we're going to be having a very fruitful day. One case that I did for S.E.L.F., Christina, we talked about, it was a fully funded outplacement. I mean, we did the district a favor by not suing them, right? And it was a fully funded through S.E.L.F. For the attorney's fees, but we got the district to pay multiple years at a private special education school because the evidence was just so terrible that they wanted to resolve it through mediation. Right. So it really depends on the facts of the outcome. But the other thing that I was just going to mention is in unilateral placement or outplacement cases, you also want to think about if you're successful in getting some funding towards the placement that you've chosen or that the district has agreed to, is the district paying the school directly or are they paying you and then you have to front load the cost to get reimbursed? And do you have those finances,
are you able to
available?
Right.
Otherwise, you can go through the whole mediation oblivious with the assumption that they're going to pay the school when in fact they're going to be paying you after you've paid the school first.
I've got two tests for a successful mediation. One, is this as good or better than we're going to do from a hearing officer with costs attached and risk assessed? That's one. And two, is it doable? I mean, particularly for an outplacement, can the parents make it happen for the amount of money being offered? Those are my two basic tests. I wanted to say one more thing. This is my normal speech. It is not all about the money for the district. It is not all about the money. And you make them a real mistake if you think that's what the negotiation is about. There's ego and pride and avoiding outplacements and all sorts of factors that affect the school. And so it's often the case that whatever we're offering is substantially less than what the district would otherwise be paying, but it's not what they want. And so money's a big factor, but it's not the only one.
It's not the only factor. Absolutely. The three of you, are, really just amazing resources in this, in this area for parents. And can you talk a little bit about your, your relationship with a parent during this mediation process? Obviously, it's, it's stressful. Who's communicating with the, with the mediator? Are the parents communicating? Are you communicating? Is it more of a, kind of a holistic, effort between the two of you? How does it work in the, in the mediation process?
So what I explain to parents in advance is that while the mediator is not a decision maker, we still want to persuade them so they can be persuasive, okay, with the other side. If I have a parent who has every detail not nailed down, and I know they're very aware of their child's needs and they're articulate about it and all those things, I'm going to set it up because the state gives the mediators absolutely no information other than the name of the child and district and who the lawyers are. The child could be 5, the child could be 15. They have no idea.
They have no idea. That's good to know.
And that's by design, right?
Yeah.
And so I start with the information I know that they're going to want to know: where we are in the process. Is there a hearing pending? How old is the child? Do they have an IEP? What's the category? All these things. Okay. After I've sort of set up what I think are the bullet points from a legal perspective of this is what our hearing would look like if we don't settle here today. If my clients are parents who I feel are able to do so, I turn it over to them to sort of fill in the color of what they've experienced, because usually it's been a whole lot of water under the bridge before I was hired. And I do that for not just because I want the parent to have their opportunity to be heard, which is a very important function of mediation. I do it because when they go in the other room, 8 out of 10 times, there will come a point in the day where the school district takes the position that it's the parent who's being unreasonable, or their expectations are unreasonable, or that they're in denial, or they're impossible to work with, or their credibility is to be questioned for whatever reason. And I want the mediator to be able to say, I've been in that room with that family for a little while, and I have a pretty good sense that they know exactly what they're talking about, and I'm not going to buy that. That's part of it. We do have clients who are not in a position to articulate well their legal position. And I don't necessarily want the school district to be able to exploit that in this process. So I'll do more of the talking in a case like that. That's my strategy.
What I do, I always send a pre-mediation statement to the mediator and to the other side, explaining the case. That's usually a 1-pager, not a whole lot more. But I just do that as a matter of practice. It focuses me on the case, and it also mediators really appreciate it. And in most mediations, not in the special ed context, it's a requirement. So this is good practice, I think. Then I prepare the parent to give a concise, clear story, and have the parent talk first. Then I end up with the demand, numbers, money, placement, details of it all. And that's the way I do it, but there's no right way or wrong way to do it. I think Jen correctly, but sort of sickly pointed out that so many of these disputes are parents do not feel heard, and mediation is a chance for them to feel heard, and so we shouldn't pass that up.
So the way I handle, it's very similar. We all kind of get to the same goal here, but I file a little bit more of a beefier, longer pre-mediation memorandum that is going to look and feel like a due process complaint. So if we are not fruitful at mediation, I'm just dusting off the caption and filing it, before I go home, the day of mediation not being fruitful. So the district knows that we're just not going to, wait. There's no delay. We'll just go ahead and file. I will often have various folks on kind of standby for the day, whether it be their therapists or the outplacement that the child has, assuming toward, been accepted to, the parents have looked at it. You'll want to know, if you've gotten any financial aid, or if there's any grants, or there's any discounts, anything that can be written off that we would have to show to the district that there's some type of discount. So I kind of put all of that together. I let the parents give a statement, and then I usually, like Andy, I'll usually handle, most of the kind of the back and forth negotiations throughout the day. Sometimes it's useful for the mediator to pull both the board lawyer and the parent lawyer into a separate chat room if there's just like this total disconnect going on and we're not getting anywhere. Sometimes it's useful to actually have a face-to-face or a virtual face-to-face with the board counsel, which keeps the mediator honest, but also keeps both the lawyers honest as well. Done that. So,
well, just in terms of, Jeff triggered something for me. It is not infrequent where the tuition is $70,000 and the district's offering $30,000 and the parents can't afford more than $10,000. Where I'll get on the phone to the placement and see what I can do about adjusting prices. I will try to I'll call the insurance company to see if we can get some money from them and try to put together a deal which makes it feasible. Often it's not possible, but often it is. Often there are ways around that, and it's and there's often all sorts of questions, particularly about private placements, about what they're offering and what's available and what the time schedule is and when tuition's due and all that. And so I make lots of calls during the course of a mediation, in many cases.
On behalf of the family. Do you all know, I have a question in the chat. There seem to be obviously this is a webinar that's available to everybody. There's some questions about, whether attorneys have always been allowed in mediation in Connecticut. Is that something that, that's always been a right that, that we've had in this state?
As long as I've known about it, Andy, I think can verify.
Yeah, I mean, I also think federal law requires it, and I saw the comment.
I know, but I
not allowing it. I think that's
illegal.
that's not sustainable.
I agree. I think it's indefensible, and I've heard it many times from colleagues. And at COPA, when we do training, they'll say we're not allowed to have lawyers at mediation. I'm like, that's completely not. I don't think it would stand legal scrutiny, but these are usually states where there aren't a lot of parent attorneys, unfortunately.
Right.
It's also, there's also the resolution session, which was adopted in the 2003 reauthorization. And at that, the preference is not to have lawyers, but, to the extent we do resolution sessions in the state, often we have lawyers.
Can you talk about a resolution session as it, and how it differs from mediation and kind of where it is on this continuum of, of conflict resolution, of which due process is sort of,
So a resolution session is only offered and required after a parent has filed for a due process hearing. Although I have heard some directors say, let's go to a resolution session, meaning when they really mean a mediation. And it's not but the term actually is you filed for a hearing, the school district has to offer a resolution session. It is not confidential, unlike a mediation, and it doesn't have required members like an IEP meeting does. It could be the director and their lawyer, or the director and the special ed teacher. It could be just the director. There's no requirement. It is the only forum where the school district cannot have their lawyer if the parent doesn't have a lawyer. If you bring your lawyer as a parent, they can bring theirs. But if you go on your own, they're not allowed to.
Resolution meeting, they're not allowed to bring their lawyer.
They're not allowed to, which is not true of any other forum under the statute. Okay.
And does that mean like you're in a Zoom? Like, does that mean they're not calling them during the Zoom? I mean, nobody really knows what
I
people are
almost
doing.
never use resolution sessions. I find them very ineffective, and I don't like that they're not confidential. So if you concede something, it can be used against you in the hearing, and vice versa for the district. And they're really just, I think, an opportunity to cure the IEP before heading into litigation for the school district, and which can be good if they're actually going to cure it. But if it's just litigation strategy, just making their case better. So that's the nuts and bolts of, I would say most of us mutually waive them. But what happens and what families should know is if you go to a mediation and you don't settle your case and you file for a hearing and you say, I'll waive the resolution session, the district is likely to say, we'll waive it too, but only if you go back to mediation. So we frequently have 2 mediations on cases where you have to file if you didn't file first.
Let me just say that the statute is completely silent on what a resolution session is like. And they vary from a one-to-one meeting with the special ed director to another full-out PPT meeting. And so in answer to your question of what's a resolution session like, I don't know.
It could be a totally different animal no matter what, who's talking.
I mean, I kind of like resolution sessions. I do a lot more mediations than I do resolution sessions, but resolution sessions, in my opinion, are kind of like a tactical thing where if you really want to get to the director face to face, and you just want to repeat everything that you just put in your due process complaint so they know that we're ready to go, and this is their opportunity to resolve it short of a hearing, because the demand is kind of just non-negotiable, right? It's really a humbling experience for the special education director to hear that this is what the ask is, otherwise we're going to hearing. But those are real limited kind of cases, right? They've got to be really strong cases where you're kind of almost posturing, like, go ahead, call our bluff, let's go to hearing, right? This is what we want. Did you read the brief? No, all right, well, 5-minute resolution session and we're done, right? Otherwise, you're going to mediation.
I actually go the opposite way. So many of our cases are just miscommunication between the two sides. And
well, that's 100% true.
And sometimes, face to face with the parent and the lawyers on both sides can work things out, can make sure that people are on the same page and that we're arguing about the same things. And I've had a lot of, whether they're called resolution sessions or just negotiated sessions, I've had a lot of success with that.
What happens if the agreement, like let's say everything goes well, you've had a full day-long mediation, you've agreed to something, whatever it is. What happens if the settlement doesn't agree with what you've agreed with on during your mediation? Go back to mediation?
Contract?
Yeah, the
and
contract.
my light keeps going out because I was in mediation all day today. So the contract is something that is still negotiation. So you may come to terms in the mediation and then you get the contract and it does not reflect what you thought you agreed to. And or the other side tries to put something in that you think
didn't talk about or whatever.
Right.
Yeah.
There are some standard terms that we all sort of expect are in these contracts, and we know the lawyers on the other side, we know what their standard contracts include, but every once in a while you'll get something and let's just say in mediation you came to terms about what the district's willing to contribute, but you didn't come up with a payment schedule for reimbursement. And some school district lawyers, their payment schedule is extremely onerous or requires the parents fronting a tremendous amount of money before they get any payment back. And so that's still negotiated, and so you're not bound by anything until you sign that contract. So, the fact that you came to terms in mediation doesn't mean you have a binding contract yet. That said, you're not supposed to go back on an agreement unless there's some compelling reason to do so either. But, it's not done until it's done.
No, that is true. Until it's signed on the dotted line. Jeff, you look like you have something to share.
Well, Jen just triggered something for me to, I think, share for parents. And that is, so after the contract is hammered out, right? After the mediation, after the contract signed, it's fully executed, everybody's moderately happy, right? Everybody forgets about the trigger dates or the dates that things have to be complied with and done by during the settlement time period. And whether a client is assuming the lawyer is going to keep track of it and they want continued representation during the settlement period, or the parent is going to handle those dates. What would those dates be? Dates in which to have evaluations done by, or dates in which to select mutually evaluators to have the evaluations done by. dates in which to hold the PPT, and parents sign the agreement. So they have to know these dates, I would say, just as much as the districts have to enforce them. And oftentimes you'll get into like this fog where none of the dates are complied with, and you have to clean it up, and you have to then renegotiate it. So know what you're signing, I guess, is an important part of a settlement contract. And your lawyers, all of us, will go through it with you, but you really have to take ownership of it. Put the dates
Put it in your
calendar.
calendar, put it in your calendar when you're supposed to be doing things,
Sort of as a more general point, parents have a duty to cooperate with the district in this entire process. And that's really important to comply with the provisions of the settlement agreement, to expect the district to do the same, and to and not to be disagreeable in terms of things that are not specified in the contract. I mean, very frequently, the settlement agreement will provide for the district to do an evaluation at a certain date, and then parents think that they can disagree to parts of that evaluation. The reality is that while parents do have to sign consent, if you don't consent, the district's obligation to provide for the kid goes away. And so you have to consent. Now you can, negotiate and try to argue for different evaluations or different evaluators, but at the end of the day, the parents need to consent to those.
We've talked quite a bit about, mediation, as opposed to due process. I'd love for the three of you to talk about, the difference between mediation and due process, and not, obviously we're talking a little bit about, functionally what it looks like, but, just in terms of time and, effort and money and what it means to a family to embark on one process, one versus the other, or one, in addition to, or whatever. I know they're not mutually exclusive in some cases, but, if you could talk a little bit about, what they mean, what the experience for the family is like.
Due process hearing is a trial. It starts on a day. The average hearing in Connecticut dealing with the appropriateness of a program is 11 days. They're not consecutive. And indeed, on average, it takes 6 to 9 months to go from the beginning of a hearing to a final judgment on it. These are full days. We all prefer in person. I think I speak for all of us for due process hearings. And they start at 9:30 or 10, and they go to 4:30 every day. There's transcripts, there's rules of evidence. Now, due to a change in law, the district has to go first to demonstrate the appropriateness of its program. Usually, used to be however long the parent went, the district would have their case taking them up the same amount of time. I think the same rule basically applies. If the district takes 4 days to present its case, we have basically 4 days to present our case. It is emotionally and physically draining. It is there are frictions between the client and the attorney are frequent. We end up with these massive evidence books. The districts tend to put in the entire educational record, often much of it irrelevant, and we tend to put in a lot of stuff. So we may end up with 300 exhibits, printed papers, passing exhibits around. A lot of irrelevant stuff going on. Hearing officers do not manage these hearings. If I ever tried in federal court to do what I do in a due process hearing, the judge would remand me many times. I can't do that. We all have our own retainer agreements as to how we bill for it, but I have never done a complete due process hearing in less than 200 billable hours. Now, very few people pay for that, and I do some of it on a contingent basis, but I'm not doing it completely on contingent basis.
Right.
And so it's a very expensive proposition.
Mhm.
The advantage is that if you get a ruling, that then becomes the placement, it then becomes stay put.
Mhm.
Which means it can last for years in the future. And you are entitled to attorney's fees if you prevail. I guess lawyers in Connecticut prevail about 40% of the time, whereas pro
Mhm.
se parents prevail about 5% of the time
Mhm.
in hearings. I think that may change now that the courts have to go first. It's a grueling process,
Mhm.
and I don't know how about but the two of you, but I haven't done a due process hearing to completion. And, in the last 10 years, I've probably, done, I don't know, a couple hundred cases through mediation. I think I've maybe done one or two or three through a full due process hearing, maybe more.
So we litigate more of them than that, but not a lot more. I mean, we've gone full calendar years where we've filed, 50, 60 hearings and only gone forward in one, or sometimes in
Mhm.
none. Then we've had years we've gone through two or three. It is, as Andy said, it is inherently risky. If you look at the analysis, it hovers around 50-50 win-loss rate, depending on what you consider a win. And
Mhm.
many times families or districts win some, but not all of their issues.
Mhm.
It is also not impossible to go through a full due process hearing with your child's school district and come out at the other end with a decent relationship, but it's very, very hard.
Right.
Once you're in litigation, it is sleeves, are rolled up,
Yeah.
gloves are off, and it can get ugly. And it's very hard to unring that bell. And
Right.
I say to parents, if you've got a long time for your child, unless you're planning to move,
Yeah.
or we're pretty certain that if we win this, it's not gonna, because even when you win, sometimes they'll appeal it. I think parents appeal more than districts do in Connecticut, but they can still appeal it, or they can fight you on your fees or whatever, or they can pretend that they're already doing what the hearing officer ordered. I've had that happen before. That kind of thing. It's inherently risky, it's expensive, it's a miserable way to spend your day, is in a full hearing all day against your child's school district.
Or your
And
months, because it seems like it
Yes.
lasts, a very long time.
It is a very long time. And then you have post-hearing briefing, and then you have, time to wait for the hearing officer to issue their decision. It's a long, arduous, expensive, risky process. It is necessary in many cases, but at least the filing of it. We're pretty lucky in Connecticut that most cases that get filed do resolve themselves, without having to go to what we call a fully adjudicated decision. But it's not for
Mhm.
the faint of heart.
Yeah, I think Andy mentioned it earlier. You're going to need an expert to assist in convincing a hearing officer that the district's program is not appropriate, right? And who that expert is,
Is
and
important.
what they're opining on, and how the expert came into the case, and at what time in the case, is all really important stuff. But like, as a general rule, it's so expensive to go to hearing that
Mhm.
I generally will tell families, look, any funding that you're looking to put into a retainer with my firm or any firm to go to hearing, what if that money could be placed into a program that you want your child to go to, and the district, throws in some every day of the week? I think everybody that does this area of the law, and especially Andy and Jen here too, we're going to say, don't put it towards us, put it towards your child's education at mediation, whatever that amount is, and get it done. Because you run an inherent risk of getting a bad hearing officer.
Mhm.
You don't testify well as a witness. Some parents are nervous,
Mhm.
right? So I mean, there's a lot of variables when you go to hearing, but it is not for the faint at heart, for sure.
Well,
And
let
you
me
can't get expert witness fees back under a Supreme Court decision called Murphy's. You get your attorney's
Right.
fees.
But not your expert witness fees. So for example, if you had your psychologist, come to testify about the evaluation they did on your child, and they charged, $200 an hour, which is their time plus an hour to travel, for this, you aren't entitled to that, to that amount.
I also have to say that cross-examination is the most egregious form of abuse that's legal in America. And we certainly love cross-examining the other side, but for the parent, and there are some lawyers in this board lawyers in the state who spend their entire time trying to prove that the parents are bad people.
Mhm.
And so it can be really
Mhm.
really devastating.
Mhm.
But I don't want to
This
paint
is
too
really
bad.
personal. It's like, it's very personal process,
I don't want to paint too bad a picture because I love doing
Me
hearings.
too.
I mean, it's the NBA for white boys, as I used to say, but it's white boys and girls. It is, it's great combat.
Mhm.
You should know that dispute resolution started off as trial by combat at the
In the
11th
in the
century in
middle,
England.
that's right, it certainly
And
did.
so this is, intellectual combat, but it's
Mhm.
combat nevertheless. And it
And
can
it's
be
just fun
fun.
to have to be, and when you sit in an IEP meeting after IEP meeting after IEP meeting with some of these administrators, and then you get to a meeting where they actually have to answer your question, it's so much fun. There's
Oh, yeah.
I've had a couple questions in the chat about supporting a family. Like what happens if you're a family that doesn't have the financial resources to fund a due process hearing, and particularly if the district is aware that a parent can't fund representation at a hearing.
So I'll field it really quick here. So first, you have to reach out to Special Education Legal Fund, right? I'm not putting that as a plug. I'm saying it genuinely. Like, there are grants that if you qualify, you can get one of us or our colleagues that do this for a living to represent you, thanks to Christine Lai's Special Education Legal Fund grants. The other thing that I'm going to say is, a lot of times parents think the only recourse is due process. And there are a ton of steps before due process that you might not think are available to you, but when you talk with a lawyer or an advocate, they are available, but you're just so honed in on due process that you might not think there's other remedies or recourses that you can resolve. Those are things that I wanted to say to answer that question, because I saw it, and I think that's a valid question to be asking all of us.
And do not go to due process to punish the district. You
Mhm.
end up suffering much more yourself than they
Mhm.
suffer. After all, they're paid with your money.
Right. That's a great point because, and
yeah.
Jen, I'll let that's a great point because, just as someone who has been through this process, not through the hearing process, but, you kind of live and breathe this the whole time as a parent that you are, that you're going through it. I did not sleep a full night's sleep for, 18 months, and that's, just it's a difficult way to live, it's difficult. So it should be avoided if at all possible.
Well, I'll tell the story. Julie Swanson, who, as you referenced earlier, is a wonderful advocate in Connecticut and my co-author on our book. Julie was my late father's client many years ago.
Mhm.
And she lived and breathed it, and it was an ugly hearing, and it was very, very contentious. And many years later, she became a professional advocate, et cetera. And I had a hearing involving a parent who was genuinely, I thought, kind of losing it. Like, I thought I was worried for their mental health. They had
Mhm.
become obsessed with the hearing.
Yeah.
They were I was worried for them. And I actually asked if Julie would speak to the parent, because she'd been through it as a parent and I hadn't.
Mm.
And after the call, Julie called me and she said, "Did I sound like that when I was going through my hearing?" And I said, "Yes, you did."
Yeah, you did.
You did. You
Yeah.
sounded just like that.
Yeah.
And there's a quality of life question that you have to ask yourself before you go for it in your
Yeah.
hearing as well.
There is, I am trying to respect the time. There are so many questions in the chat. We're not, obviously going to be able to answer them all. I think the one of the questions that I wanted to pose is that is from the chat is the question of retaliation. And what do you recommend in the instance where there's retaliation, either, because the parent has filed, for due process, or, perhaps there's a state complaint? What do you advise parents to do in that situation?
It is extraordinarily hard to prove retaliation as a legal matter. So the notion of, I mean, there are causes of action for retaliation under federal civil rights laws, and one can pursue that. But the case would have to be extraordinarily strong before I'd ever pursue that. I think I don't see much of a remedy for perceived retaliation, except to call it out.
Yeah, sometimes it's really obvious, like the day after you filed a complaint, they referred you to DCF or something like that. Sometimes it's pretty obvious, but I agree with Andy. It's usually not worth pursuing. It makes the district look really badly if there are facts like that. And so you want to bring them out in the hearing or in the mediation, right, for sure. But I usually just document it with an email to the opposing counsel saying, the following just happened. This smacks of retaliation. I trust you're going to discuss this with your client. And unless there's been some, terrible thing that has occurred to the child where we have to address it, that usually ends it.
Can I, let me just spin off of what Jen said for a moment. DCF referrals. Districts, every teacher and professional has to go through annual training on mandated reporters. DCF overinterprets the law and basically tells people if there's even a hint that there might be abuse or neglect, report it to us. Mm-hmm. Over 80% of cases referred to DCF are found to be without substance. And so, yes, districts do it. They do it in retaliation. They do it to punish parents. My advice is, cooperate with DCF and don't worry about it too much. DCF is not in the business of trying to, punish good parents. Mm-hmm. It does give you a chance to talk about what the school district is doing, but this is something that really, really terrorizes parents, and it should not.
And it happens a lot. I mean, I would say a very large number of the clients that we see through S.E.L.F. Have been a part of that process initiated by their school district, perhaps in relation to the conflict that's happening between the parent and the school team over the student's, educational, process. So it is very, it's very common, unfortunately.
And the place where it happens perhaps the most is the parent decides that the school is a hostile environment for their kid and will not send their kid back to school. Mm-hmm. And that will lead to a charge of parental neglect.
Right.
DCF come out. And so if parents are going to do that, they ought to, consult counsel and get involved in the process fairly quickly to protect themselves.
Yeah, for sure. I mean, we all have the parent that will say, there's no way that my kid's going back to school tomorrow. And then they retain us and we're like, well, wait a minute here, right? So if you don't want your kid to go back to school, there's got to be some type of expert that's stating that your child is in such a heightened, anxiety or there's something that's
depressed
hearing about school.
It's detrimental.
Get a wellness check with your pediatrician, or if there's usually there's a therapist involved or something, right? You're going to want to try to trigger the homebound instruction statutory requirements. Otherwise, you're getting a referral DCF. And the thing about it always annoys me, right? Parents are contacting us because they genuinely are caring about their kids' education. Mm-hmm. But then DCF gets involved because supposedly they're neglecting their child's education, but yet they contacted folks like us because they care. It's so counterintuitive. It's, you know, so I often agree. Yeah, I think districts will do it to give it to the parent, but it's really hard to prove retaliation. And I try to let the emotion of it dissolve. Sometimes I'll actually get reports and speak with DCF to see how favorable they would be, and it just being so frivolous, can they add some colorful language in their closing notes, right, to help advance our cause. But
Which brings up the whole area of bullying, and I think you ought to do a separate webinar on that. We've just changed the law in the most massive way on bullying.
That is a great idea.
And,
That's
you know,
a great
it's
idea.
really important people know
yeah.
what's going on with that.
Absolutely. We've never done one. That would be a really interesting topic to explore.
Oh, yeah, we know that disproportionately kids with IEPs are targeted far more
Yeah.
than their non-disabled peers, so.
No, that's 100%. That's a great idea. And I'm embarrassed that I've never done a webinar on bullying and never like even because we talk about it all the time. I'm going to throw out this last question to the panel. Can you talk about other ways that you can to resolve, you know, a dispute in special education? You know, obviously we've talked a little bit about due process. We're talking about mediation. You know, we talked about the resolution meeting. You know, are there other ways in which one might look to resolve a conflict with a school district or school-based team?
I think mutually agreed upon evaluators is a very good tool where, but you know, we have a group of evaluators that school districts see as parent hacks. We have a group of evaluators that parents see as school district hacks. And then there's a bunch of not as many as we'd like in some disciplines, but evaluators that everyone thinks are pretty fair. And so it's a very good way to resolve a dispute to say, look, if you're right, then I'd like to hear about it from somebody who I trust.
Right.
And you'd like to hear about it from somebody you trust. Let's get this person in to do a records review or a program review or an evaluation and advise the team. And that's a very common tool and a lot less expensive and a lot less acrimonious way to try to get the parties back on the same page.
yeah, I mean, I'll often try to give the analogy that you're clinically adjudicating it. I mean, there's no legal precedent for it, but if you're getting and you're building a team of neutral evaluators, right? Everybody then can start to submit their own concerns and questions to those evaluators. So to expand on what Jen's saying, I'll often have parents prepare parental concern questions to submit to the mutually agreeable evaluators, and then invite the district, if they so choose, usually they don't, to submit questions to the evaluators. So now the evaluator is aware of the gravamen of what the parental concerns are. And if they have something to say about it, we're putting them on notice that we're inviting them to hear the parents' concerns and opine something from their clinical, seat about what might be more appropriate for the child's program. And that could be done, through the PPT process, through negotiating, and so forth.
There's obviously also state complaints, which is a dispute resolution mechanism, which we've talked about. There are parents who think, I'm going to go to the newspapers and I'm going to embarrass the district. Most times that does not work. Are times when that does work. There's school districts are complex political organizations, and often there's leverage within there. If you analyze it, and can parlay that. That's a difficult and strategic process. And there are, outside influences, state legislators, school board members, none of which are going to get involved in the details of it, but they may call the superintendent and say, come on, let's fix this one. And that can promote settlement. So, I mean, I think, I think there are those mechanisms too. That's earlier in the process before things get really in loggerheads that things like that can be done.
And usually, I mean, you didn't mention this, but, I know you're all thinking of it, is that, your child is going to be in the system for a very long time, and, you know, they're probably going to be in the system after this, process. Very few kids are outplaced for the entirety of their educational career. There's probably some point in the future that you may want the school district to be involved, whether it's transition or, whatever it is. So sometimes it's not entirely productive to, to take the route that, Andy was speaking about. In terms of, going to the media and, and doing a whole, kind of song and dance, that way.
Well, and you just raised a very important point, which is that in question is the IEP for the 24-25 school year. And that's what you're settling, unless there's some agreement to settle something beyond that.
Mhm.
Now, if you get a ruling from a hearing officer, there probably is stay put attached to it. But that's the rare case. In mediation, we generally end up settling for a past year and a future year and maybe a second future year. But after that, you're back into the process. And so parents often come to me and say, do I have to go through this again and again? And the answer is, yeah.
Yeah.
You probably do.
Yeah.
And keep in mind that, these are decisions based on the individual needs of your child. And many parents will come to us with a report that just came out about their school district, or an article from the newspaper about how many
Or something
parents
that they had, their neighbor that happened to their
neighbors,
child.
the hearing officer is not, with some exceptions, the hearing officer is not going to care what the district is or is not doing for other children, period.
Right.
They want to know whether or not the IEP offered to this child meets that child's unique needs. They're not going to do a deep dive into whether you have a nice director.
Right.
And in that line, parents often come and ask about class action suits. Class actions are generally unavailable in this area because each student is individual. The only sort of class relief would be if there's a published policy which violates law that you can somehow join. But in terms of seeking relief as a group, it can't be done.
Yeah, there's also a cliche that I think is worth sharing with parents, and parents that want outplacement generally are not offered it, and parents that are offered it generally don't want it, right? And the space in between the two is often what gets mediated and litigated, right? So if a family's being offered outplacement, it's probably because the district cannot appropriately handle the child, but yet the district has not exhausted the least restrictive environment, push-in supports, and so forth. So there might be a due process action where the family's wanting the child to get more supports inside the district, right? But generally, it's the other way around, where the parent is just randomly asking for outplacement without a plan in sight, without a tour, without a shadow day, without an acceptance. And those are the times that I think, and maybe others will disagree, but those are the times when I don't think a parent should be asking for outplacement. I think they should be consulting with an advocate or an attorney first, because the minute a parent asks for outplacement, the special education director is going to take a second look at the case and make the IEP in district that much more defendable. So then you're making our jobs harder to potentially get the outcome which your child may very well need, but now the district's 10 steps ahead because they're already cleaning up the IEP because you asked for something that you weren't ready to ask for yet.
That's a great point. And on that note, I know there's a ton of questions. Obviously, we'll have to arrange to have, mediation and due process part 2 with Andy, Jeff, and Jen. I want to thank all 3 of our participants this evening for lending their expertise, their knowledge, and the wealth of knowledge that's being shared right now on this webinar is really truly tremendous. And, I just want to thank you all for, for participating. Our next webinar is February 28th at 7 p.m., supporting students with autism in schools. You can sign up on Eventbrite the same way that you signed up for this and all of our webinars. And I want to thank everyone for joining us this evening. This is a great end to a, kind of a snowy day. Be well. Thanks a lot, everyone. And, see you in February.